Welcome to Sakshi TV's special immigration show with attorney Bhanu Babu Illindra from BBI Law Group. Please note that Sakshi TV now has 3 immigration shows every week. On Wednesday at 5:30 p.m. EST with attorney Ms. Prashanti Reddy in English, Thursday at 5:30 p.m. EST with attorney Chand Parvatneni, and on Friday at 6 p.m. EST with attorney Bhanu Babu Illindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice. Use of content is for general informational purposes only. Sakshi TV or its agents in the USA or our guests on this show are not responsible for use of information as a legal advice. If you need specific legal advice, please contact attorneys directly. Mr. Bhanu needs no introduction. But if you need consultation, please log on to ilindralawgroup.net for contact information. And when you connect with them, don't forget to mention Sakshi TV. From the beginning, ilindralawgroup.net has put a wealth of free information and online tools in the hands of the immigrant community and for the benefit of US employers. The ilindralawgroup.net site provides you with latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. We will also be taking any general questions along with today's topic. And today's topic is latest immigration updates. This is continuation to the last week's topic. We will continue the knowledge session this week along with news and updates on latest immigration, followed by Q&A. Before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask for tips. Hello Bhanu Garu, welcome to the show.
Thank you, Tarani Garu. Thank you very much for welcoming back to the show.
Hope you're doing well, sir.
I'm doing good, thank you.
Right, so we'll start off with our topic for today.
Yes, we can.
Right, so there are some questions that we got, so I was thinking we'll start with those.
Sure, definitely.
Right, so the first question is, can a person apply for 2 H1B transfers at the same time, Bhanu Garu? And what do you have to say about that?
Yes, they can. They can apply for 2 transfers, and they have a right to choose which employer they would like to work. And if both employers who would like to file a transfer for him or her, and yes, they can do that. Yes, answer is yes.
Right. So does an employer need to pay the required wage set forth by the LCA?
Yes. Employer is required to pay 100% of the wages set forth by LCA. With whatever the offered wages on LCA, those are the offered wages will be stated in H1B petition as well, and employer is required to pay 100% of those. There is no leeway on that for the employer.
Right. Right. So, and what are the steps that an employer can take if they want to change their employee status from full-time to part-time status? What are the steps that are involved?
The steps are involved is that they have to, if it comes to the immigration point of view, USA's point of view, the requirement is that they have to just file an H1B amendment, and if the employer required to file an H1B amendment, in order to file an H1B amendment, they have to obtain a new LCA, and that LCA should clearly state as that this H1B petition is filed as a part-time petition, and based upon that, and once the LCA is certified, then the employer should prepare H1B petition from I-129 and its supplements, along with the supporting documents saying that employer is actually going to hire this individual as a part-time employee, and therefore they're requesting the amendment to file this petition as a part-time employee, and accordingly they have to file an amendment to the H1B petition. However, you have to understand this: if the employee is going to work in the same or similar position, but from full-time to part-time, then I think the employer should document the reason why they're converting the position from full-time to part-time. Is the business needs have changed, or the position requirements have been changed in the company? Is it only for this employee or for other employee? It's better to have those documentation and keep it ready tomorrow. If any site verification happens, they can actually show that, but that is not necessarily required. The main important thing which employer has to worry about is that timely obtaining amended LCA for a part-time position and filing an H1B amendment for a part-time position so that employee can continue working in a part-time position without violation of their status or without violation of the H1B regulations. So that is very, very important.
Right, right. So, moving on to our next question. What steps does an employer have to take to terminate its obligation to pay the required wage?
The employer can only terminate the obligation to pay the required wages only when they terminate the employment of the H1B worker, you know, and 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 there are different steps needs to be taken by an employer at the different situations or different scenarios. For example, if the employer brings the employee from India, to hire them as an H1B worker, and if the employer voluntarily or involuntarily terminates the employee, then employer required to issue the notification to the employee saying that they're being terminated, his employment being terminated, and also must be offering a flight ticket, a return flight ticket to back home to home country from whichever country they're bought from. For example, if they're bought from India, the employer to do that. If not, if the employee actually filed for the change of status or for the transfer of an H1B petition within the United States, then employer need not require to offer that flight ticket or return ticket to India. Only employer is required to inform the employee orally or in writing that the employment has been ended and they would like to withdraw their H1B petition as well. Once they provide those notifications in the both scenarios, then employer is required to send a letter to the USCIS requesting for the withdrawal of the H1B petition because the employee is no longer working and the employment ended. If they don't do that, then it constitutes an improper termination of an employment. And if it's an improper termination of an employment, the employee can always have a claim against the employer and demand back wages from the employer, although it did not work for the employer. So it's important that employer, upon termination of an employment, send the withdrawal notice to the USCIS, stating and notifying the USCIS that the employee is no longer working for them as the employment ended with them. As I said, employment can be terminated in the US at will. What I mean is for reason or for no reason. So it all depends upon the what kind of employment relationship it is and where the employee is coming from and everything. That is only the way employer can terminate his obligation to pay the required wages to an H1B employee only upon proper termination of the H1B worker's employment with the company.
Right, right. So, moving on to our next question, sir. What will happen if a person wants to transfer their, visa from H1B to J1? I mean, is there, and will they get 6 more years of expiration, of 6 more years of H1B after their expiration of J1? Is that possible?
There are two questions in this, Thornigar, what you asked me. One is whether H1B worker can change to J1 or not, and what are the obligations they may have if they change the status to J1 as an exchange visitor in the United States. Usually, the J1 programs are usually authorized by the non-profit organizations like hospitals and colleges and universities, especially for the doctors, individuals who are in the medical profession or in the teaching profession. They are the ones who actually come into this country as an exchange visitors on J1 visa. Or somebody who's coming on a training for a J1 trainee or au pair programs, then they can come on a J1 visa. These are the exchange visitor visa programs. And for the J1, somebody wants to change from H1 to J1, there is no issue at all. They can change. However, once they change to J1, if the J1 requires a 2-year residence requirement, what I mean to say is that upon completion of their training program or upon completion of their residency program or whatever the purpose they actually sought change of status to J1, if they have sometimes they may have a 2-year residence requirement going back to home country and staying in home country for 2 years. If that happens, then they may have to go for the home country for 2 years once they complete their program. Or what they can do is, if they're eligible for any waiver for the 2-year residence requirement, they have to petition or apply for that such waiver. And once that waiver is approved, then they can change the status to again any other non-immigrant status. If they're eligible for H1B, H1B. If they're eligible for L1, whatever status they're eligible for, they can change their status to other non-immigrant status or immigrant status. So that means if they want to become a green card holders, their employers are willing to sponsor them green card, or if they're eligible to self-petition under EB1A, they can also do that, or under I-1 or EB2 national interest waiver, yes, they can do that. So those are the things which we have to understand. So if second question you're asking is that if somebody is on H1B for 6 years and if they change their status to J1, and then once they finish the program on the J1, again, will they get 6 years H1B if they want to change the status to H1B? The answer is simply no for that. The reason why answer is simply no for that is that if somebody exhausts the 6 years and if they do not have a labor certification or I-140 pending at least for 365 days, or I-140 has been approved and the immigrant visa numbers are not available for the individual based upon the per country limitation where the individual is come from, then he is not eligible to continue to stay in this country on H1B beyond usual 6 years, irrespective of whether he's changed to some other status and coming back to H1B or not. The only way he can get the fresh 6 years H1B is that he needs to physically stay outside the United States for 1 year. Once he stays physically for 1 year, then his cap resets and then he's eligible for applying for the next cap whenever he meets that 1 year requirement. So those are the two different scenarios which you asked. I hope I provided the clarity on the both scenarios though.
Right, definitely, sir. So we have a caller on hold, Mr. Chand Babu from Hyderabad, India. Thank you for calling, Mr. Chand.
Yeah, good morning.
Good morning. Hello, thank you for calling us, and you may speak with Mr. Bhanu directly. You can ask him your question.
Yeah. Good evening, Andy. My son's chasing Dallas. He's working for Cognizant. Last time he was picked up H1, but after RFE, his petition was denied. Again, he got this one. He was lucky enough to his petition was picked up again. Yesterday, he got a mail from his employer that his petition was picked up. Now, are there any chances that last time he was denied the visa again? Will his petition will be denied this time also?
It's very difficult to tell. Every time when you apply for H1B petition, H1B visa, or H1B status in the United States, you always have a burden to prove that you do qualify for the position and the position actually qualifies as a specialty occupation. So I do not know the circumstances why it was denied in the past, and if he cannot overcome those requirements or those factors which actually resulted in the denial of the H1B petition in the past, then it may likely result in denial again this year also. However, if they figure out exactly what the reason was, and if they correct it, and if they file it properly by preparing H1B petition properly for the position for which your employee, which your son is intended to be employed with Cognizant in a specialty occupation, and if he qualifies for it, then it may get approved. So always whenever you try immigration benefit, there is always the possibility that the benefit can be denied. But as I said, it's more likely than not the petition will be approved if you meet the minimum requirements as stated by the regulations. If you can provide the documents under the preponderance of the evidence standard, which is more likely than not, then the petition can be approved. So I think my answer is very limited because of that reason, because as I said, yes, there is a possibility that it can be denied, but if the petition is properly prepared and properly filed, I don't see any reason why it won't be approved. That's my answer.
Right. So I hope that really cleared your question, Mr. Chand. Thank you for calling. So moving on, Bhanu Garu, my next question is, what if a person is on L1 status and their H1B is approved? I mean, does that mean that the USCIS will cancel their L1 visa as soon as the H1 gets approved?
There are two scenarios here also. One is if the employer requests for the H1B change of status, right? And if the H1B is approved with the change of status, then automatically L1 gets cancelled, because H1B change of status is approved and H1B change of status comes into effect from the day the approval effective date comes in, right? For instance, during the cap season, the earliest start date you can ask is the October 1 of the particular fiscal year, right? And in April or May, June, you file the H1B change of status from L1. And if the H1B gets approved with the change of status approval, which is effective from October 1, 2022 or 20, whichever the fiscal year is, automatically their status will change to H1B from L1 because they requested for the change of status. If not, and there's another type, another way also H1B can be approved, that is that employer can request the H1B to be approved with the consular notification. That means it requires the employee to go abroad, apply for a H1B visa, and then come back into the United States. If the employer seeks for the consular notification of H1B approval instead of a change of status in the United States, then L1 status will remain intact till the date that L1 is valid for that employee. Okay, so there are multiple ways it can happen depending upon how the request has been made by the employer at the time of filing H1B petition. Most of the employers do file for the change of status in the United States effective from the whichever date they want to employ to start with an H1B. So automatically when H1B is approved, they may lose L1 status and they will be considered an H1B status. And if they're not employed with H1B employer, then they may be considered out of status because of that.
Right, right. So, Bhanugaru, what happens if a person is on L1 visa and they want to start their own business? Are there any limitations or restrictions there, or should this person have a green card to start their own business in the United States?
See, the L1 visa, H1B visa, these two visas are employer specific visas. That means you can actually only work for the employer who actually sponsors you these visas. Otherwise, you have to transfer. If you want to work for another employer, then you have to file for a transfer on H1B visa or L1 visa. Unfortunately, L1, you cannot even transfer because unless you qualify as intercompany transferee for the transferring company also. It's very, very difficult to happen that one because the requirements for L1 is as an intracompany transferee is that you have to work at least for 1 year within the past 3 years for the entity which is actually intended to bring you to the US on L1 from the foreign country. That means from India or whichever country they are from. Therefore, legally speaking, they cannot directly involve in the operations of any business that is owned by them. They can be a passive investors in any business, but they cannot be an operating members or operating directors or operating officers in the company where they can run the business on the side while they're working for an employer in L1 visa. Only the time they can do that is that if they have any employment work authorization other than L1 visa. Like for example, if they file for the adjustment of status in this country and waiting to get their green card, and if they get the work authorization based upon that, yes, they can own the business and they can do the business and also work for the employer at the same time in the position for which they have been employed for. Otherwise, L1s should not do their own business where they're actually involved in operating the business or running the business.
Right, right. So, but Bhanugaru, what is the situation if a person is on their 9th year of extension, and what if they want to shift to a different company? Is that possible? And if yes, then what's the procedure?
It is possible, and answer is yes. It seems like if they're in the 9th year of H1B extension, that means they must have already had an I-140 approved for them, and or I-140 is pending, or labor certification is pending, at least for 365 days, or I-140 is approved, and their immigrant visa is not available. If that is the case, then they should be able to file for the transfer with a new employer with the proof showing that either the labor certification or I-140 is pending for at least for 365 days, or I-140 is approved and their immigrant visa numbers are not available. And if they can provide the proof of that, then they should be able to transfer to any employer seeking the extension beyond 9th year extension. As long as they meet those requirements, there should not be any problem for them seeking an H1B extension.
Right, right, okay. So, but we were talking about starting a business for an H1 or an L1 employee. In regards to that, what if a person, if like a, a H1B visa holder starts a firm with a citizen of the country and then later transfers their visa to that company? Is that possible?
It is possible. Okay, there's a legal nuances here is this: the entity is always a separate individual. Entity is considered to be a person. Any company is considered to be a separate person. A person means it need not be a human being. Even entities can be a person, basically. The entity is a separate, any company is a separate entity from its owners, especially if it's a C Corp or S Corp. It's very easy to show that the entity is a separate person from an individual who actually owns that company. The prior to 2011, it is actually possible under the theory of the corporate law that the company can actually sponsor the individual who's also owner of that company. USCIS never had a problem in that way. For example, in 2009, I actually did the same thing with my firm also. While my green card was pending, I decided it's safe for me to have a non-immigrant visa at the time because I was working on based upon work EAD. Then I went and filed for an H1B from my firm to myself as a owner of the company because my firm is a separate entity from myself. However, USCIS said that yes, that legally that is correct, but however, how do you show who's actually making a decision, who's actually controlling the company? And if there is no if there's no other person or individual involved in the company to make a decision on behalf of the entity, then there is no bona fide job offer. This is what the Neufeld memo in 2011 came up under this situation. And in 2011, the Neufeld memo came in, USS memo came in, and explained that the individual, if he's a 100% owner and if he doesn't have any other owner or any other individual who cannot make a decisions on behalf of the entity that is binding on the entity overall, then that individual cannot do H1B by himself. That means if there's any other person who's a US citizen or a green card holder or any other status visa holder, but if that individual has an authority to bind the organization with his decision making, then yes, the individual who started the company on H1B can actually transfer his H1B to that company and then work to that company based upon that H1B approval. It is absolutely legal. As I said, you need to have a second person or a third person who actually has an authority to make a decision that is binding on the entity, on the company. That is very, very important. If that is a possibility, yes, the individual who owns the company can actually file his H1B petition from that company, and accordingly as an employee of that company, not only as a owner, but as an employee of that company, he can actually involve in the day-to-day operations of that company.
Right. Right. So while we're on that subject, how about this situation? What if an employee, already has, is as in, okay, let me rephrase it. Can a person, can an H1B visa for a brand new company with $0 revenue be approved? As in, let's say they have all the paperwork, but the revenue is $0. As in, how much does the revenue of a company affect green card processing?
Revenue of the company may affect green card processing. The reason is for the green card processing, employer must show that it has a financial wherewithal to pay the pro-offered wages to the employee from the date especially if it's an EB2 and EB3 category, from the date the labor certification has been filed until the date the green card is approved for that individual. Therefore, rather than a revenue, I would say the net income of the entity or the net current assets of the entity are very crucial to get the green card processing for the employee. They need to have a very strong net income or very strong net current assets, or they must be already paying that wages to the employee, the offered wages for the green card to the employee in order to sponsor a green card. Otherwise, it's very difficult for them to pass the muster to show the ability to pay, and it's very likely result in the denial of I-140. Of course, if it's an ability to pay, they can still refile I-140 the labor certification is considered to be valid only, but they have to meet the muster whenever they refile that I-140 again. That is the problem with the green card. If it comes to H-1B, it's a different scenario. If it comes to H-1B, the company can be a startup company, but based upon the nature of the business, even if there was zero revenue, they can still file an H-1B petition as long as they can show that they have a bona fide business need in a specialty occupation for which they intend to hire the individual, and the hiring individual and the individual providing services to the company on that position itself will generate revenue, and that will itself will be able to pay the wages to the employee based upon that work. Then there is no problem for that.
Right.
The requirement for the H-1B is not the ability to pay, but it's about the having a bona fide offer and a bona fide requirement in a specialty occupation.
Yeah, right. So with that, we come to the end of the show, Bhanu Garu, and thank you so much for providing all those valuable insights and information for our community. And thank you for being on the show. It's a privilege hosting you, sir.
No, it's my privilege, Thorni. Thank you very much. Thank you, Sakshi TV. Today, amazing questions, really wonderful questions. Hope we'll continue similar type of questions next week also.
Sure.
That's a wonderful show. Thank you. Thank you, Thorni. Thank you, Sakshi TV. Thank you, everyone out there, and look forward to talk next week. Thank you.
Thank you, sir. You're watching Sakshi TV Live. Thank you.